and welcome to today's Lawpath webinar. My name is Ryan Tan, and we're going to be talking about navigating complex employment regulations in a challenging economic climate. It's going to be a masterclass covered by our senior lawyer, Damon, and he's going to be going through a lot of different things that you need to keep in mind in terms of regarding and looking at the most recent changes and different updates in employment regulations. He'll be going through best practices for drafting and updating employment agreements and policies, how you can avoid common pitfalls and mistakes in contracts so you can avoid litigation, and then lastly, navigating entitlements such as wage and hour laws, minimum wages, overtime, and leave laws. So just before I bring Damon on, I just want to welcome everyone to today's presentation. We do have the Q&A and the chat box open right now. So if there's any questions during the presentation, feel free to pop them in the box, the Q&A or the chat box, and Damon will answer them along the way. If not, we will have a Q&A at the end of the webinar as well. So just about Lawpath, who we are and what we do. We are a contract management and a legal documents platform at heart, and we provide our customers with 400 legal templates where they can manage their compliance and connect with lawyers and accountants in a single platform. And across the last 7 years in business, we've served over 300,000 businesses, helping them save $100 million in legal fees, and we've garnered over 10,000 five-star reviews, and just getting started on this mission as well. So again, looking forward to diving into this presentation today, specifically on employment. Now, I'll introduce Damon. He's no stranger if you've been part of our webinar series for the last year. If you're on the legal advice plan or you're across a lot of our presentations on YouTube, Damon is a senior lawyer on the legal advice plan with over 14 years experience. And he has a lot of different areas of expertise, including one of them being employment. So I'll introduce Damon to kick off today's presentation. Thanks, Damon.
Hi, everybody. How are we doing? So today we are talking about employment law, primarily about the changes that have recently been implemented, but then I'll also touch upon some other general things that might not actually be covered in the slides, but some things that people are fairly surprised about when it comes to unfair dismissals, general protections, and unlawful terminations. So to begin with, we're going to look at the most recent changes. Most of you are probably not aware of them at all. If you are on top of applicable laws, maybe you are then. But there was recently amendments made to the Fair Work Act, and that was for secure jobs and better pay. This was primarily brought in because of the new Labour government. And it's really about transparency in salaries and focusing a lot on domestic violence as well. So what we'll do is we'll look at the very first change. So it was before in the National Employment Standards that someone that had sustained family or domestic violence was entitled to 5 days annual leave or 5 days domestic violence leave. They've now increased that to 10 days. What that means is that if someone starts their employment on day one, it's not like annual leave where they slowly accrue it over the year. It's automatically granted and you automatically have it as of day one. And if you don't use it in the 1 year of your employment, then it doesn't carry over, it doesn't accrue, but it starts all over again each year. So that's 10 days every year paid family and domestic violence leave. Now, for large employers or employers that are not small businesses, that's 15 or more employees, those laws have already come into play on the 1st of Feb. For those who are small businesses, 15 or less employees, that will come in on the 1st of August, 2023. Now, what does that mean? What do you need to do? There is an ability for an employer to ask, what is it about? Why do they need it? The primary reason why those 10 days are given is to attend psychologists, counseling, court, complete paperwork, attend medical appointments, see lawyers, things like that. So you can ask, what is it about? Why is it about? But you're not allowed to use that information at all for any purpose other than determining whether that's a legitimate leave request. and you're not allowed to share that information either, and you're not allowed to take any adverse action against the employee as a result of taking that leave. Now, you should, if you do have company policies that lay out all the different national employment standards and the leaves, you should probably update your policies as soon as you can to deal with this. And you can have a look at the changes in the Act and how it applies. You can have a look at the Lawpath website. You can go to the Fair Work Ombudsman or the Fair Work Commission website, or you can just type into Google paid family and domestic leave, and it will spell out the whole guidelines of how it works, such as 10 days automatically commencing on day one. Now, the other thing that they've implemented is sexual harassment in the workplace. Now, we've always had sexual discrimination laws. We've all had just general anti-discrimination laws. But what they've done is they've amended the anti-discrimination and human rights legislation, which is a federal law, to put a positive obligation on an employer. So before it was that an employer must not harass or sexually discriminate against somebody. Normally it comes down to an action by somebody, and then they have to show that they've not actually done it. Whereas now you actually have to show that you've put a positive obligation in to prevent it from happening. So the main things that you need to do now is you need to implement reasonable steps to prevent it from happening. And if something does happen, you have to take remedial action. Now, there's a 12-month transition period, so it's not in yet. But what you need to do is have a look at implementing a policy. And you got to look at training your staff as well. So, and this is because at the end of the day, the employer is responsible for the actions of their employees. That's what we call vicarious liability. So if one of your employees was to sexually harass somebody in the workplace, they're not only going to sue that individual, they're also going to sue the employer as well. And now that you have a positive obligation as the employer, not only do you have to show that it is outside of the workplace possibly, or that employee was not, or you're not vicariously liable for the employee. And the way that you prove it is if it's gross negligence, if it's totally against your policies, totally against the environment of your workplace or outside of office hours, things like that. But if you cannot show it's absolute gross negligence and you did not take measures to prevent it, then you could be found liable. Even if it's found that the sexual harassment wasn't deemed harassment, there could still be a situation where you can have a civil penalty imposed on you for not actually implementing a policy by taking those preventative measures. Now, they've also increased the flexible work arrangements. Now, every modern award, so depending on what industry you're in, most people fall under a modern award. So if you're in manufacturing, you got the manufacturing award, hospitality award, support services award, law, the legal services award, and so on. And that, a lot of people don't know that there's an award. Most people think, well, how much do I pay my employee? They Google it, it comes up with the pay guide that's associated to your award. And a lot of people think that that pay guide is what an award is. But there's actually an award that spells out all the rules of how you're to deal with your employees. Who's a part-time employee? Who's a full-time employee? Who's a casual? If you have a casual, what's the minimum shift requirement? So to give you an idea, we have a lot of cases regarding tutoring businesses. So there's a marketplace, someone hires a tutor as a casual to take 1 hour virtual seminars. Now, there is no award for the tutoring industry if they're not an actual qualified teacher, but the miscellaneous award catches them. And the miscellaneous award says you must hire a casual for a minimum of 2 hours or 3 hours per shift. So if the business model is a whole virtual meetings for 1 hour, you have to pay that employee a minimum of 2. And so what you need to look at is what your award says on minimum shift requirements for casuals. but it also has almost always in clause 5 flexible work arrangements. Now, it used to be that you had to fall within a category to request a change to your working hours. So if you were a single parent, or if you were a parent at all, you might need to pick up your child from daycare, you might need to drop off your child, you might have to pick them up from school at different times. So you could apply for a flexible work arrangement as a parent to be able to possibly come into work an hour later, leave work an hour earlier, and then do your extra hours after 8 p.m., for instance, when the kids go to bed, something along those lines. And you would make that request. The employer has a positive obligation to consider the request, and under certain circumstances, they can reject it. But now it almost extends to everybody, primarily because of COVID, and everybody's looking for flexible work arrangements. So pretty much anyone now who's been employed for more than 12 months, who's not a casual employee, can now request for flexible work arrangements. And if they do make that request, there's a positive obligation on the employer to consider it. They must respond within 21 days. And they also have to take genuine efforts to try to reach an agreement to accommodate the requests. And as long as the requests are reasonable, there's only certain circumstances where you're allowed to refuse it. Like the cost to the company are going to be so sophisticated or significant that it's unreasonable for the employer to accept it. So there's that positive obligation to respond. You have to respond in writing. You got to outline the reasons, and you have to look at the grounds for which you're allowed to refuse. And those are all now set out in section 65A, B, and C of the Fair Work Act. And these are also amendments that are now coming in. So if the employees get wind of it, it might be all those who didn't want to come back into the workplace might now be seeking those flexible work arrangements and a flat out no, you can't. And if you don't show up, you'll be terminated for abandoning your role. That's not a defense anymore. That's not an excuse anymore, because we now have a situation where you actually have a positive obligation to consider it and only limited reasons to excuse it. Now, just a reminder, if you have any questions, feel free to ask them, and then I'll answer them at the end. Now, this is really significant. I think it was the Newman government up in Queensland a long time ago when they came in. They looked at all the Department of Health contracts, and most people that worked for the Department of Health were contractors. And Campbell Newman proposed to terminate or not extend all these contracts because they were all on fixed term contracts renewing every 3 years for years and years and years. And so they've now finally brought an end to this. And this is going to be very significant for labor hire companies, recruiters, and generally for companies who hire on fixed term contracts. And essentially what they're saying now is if you offer a fixed term contract and it's allowed to be renewed more than twice, then after that second renewal, the termination clause is void. If that period of time is less than 2 years or more than 2 years, it doesn't matter how long it is. So for instance, if you hire someone for 3 months with a renewal for another 3 months, and then at the end of that second 3-month period, you say, well, I've decided to terminate you. Well, that termination clause might be invalid because you've now renewed twice on 2 separate roles, or you've offered 2 identical contracts back to back. Alternatively, if you have a contract that has 2 consecutive terms that are more than 2 years, once they've done those 2 years, the termination clause no longer applies again. So essentially, fixed term contracts are going out the window when it comes to a general normal position and where someone's been employed for more than 2 years. Now, there are certain exemptions to this, like where it's for a skilled position, possibly where it's for a specific project, possibly where there's a training, so maybe an apprentice scenario or emergency circumstances. And it also doesn't apply to anybody who is under the high income threshold, which is where they make more than $162,000 per year. And in a way that they've treated it in legislation is they've just essentially said that the termination clause has no effect, but the contract continues. So if you do have people on a fixed term contract, it's important to consider what your next move is going to be. It's either going to be that they're not going to be appropriate and you're not going to hire them again, or if you do hire them again, you're probably better off just to put them on a permanent contract, because having fixed term contracts, not only do they make that clause invalid, they also can apply civil penalties to the employer for actually issuing them and imposing those clauses. So if you do have someone that's been around for more than 2 years on fixed term contracts, it's probably worthwhile to consider moving them to permanent or dismissing them before they exceed the 2 years, if possible. Now, a lot of people will put into their employment contracts that the contract terms are confidential and that they can't be disclosed to anybody else, including the pay. They've now outlawed, essentially, a secrecy to pay, which now allows employees to talk about their pay and allows them to talk about what the terms and conditions of their employment are, and to ask other people within the business what their pay and employment terms are. And an employer can't do anything to stop that. And any clause that's in your existing contracts that covers that is unenforceable. And this is primarily to deal with the gender gap in the pay discrepancies within there. Now, the high income threshold. Now, I think I might just bridge for a moment into another area of law. I've been getting a lot of people looking to terminate their employees, and they have a lot of questions about unfair dismissal. So I'm going to give you a very high level on employment law for small businesses generally in about 5 minutes, because it's not covered in these slides, but it's really important. So an unfair dismissal is where you terminate an employee, which is harsh, unjust, or unreasonable. So a lot of people talk about, well, do I need to give 3 warning letters? And then if I give 3 warning letters, then does that mean I can just simply terminate them? The answer to that is no. The Fair Work Commission, so what will happen is that, first of all, an employee who's been employed for 6 months or less from an employer that has 15 or more employees cannot bring an unfair dismissal. And an employee who's been employed for 12 months or less from a small business with less than 15 employees cannot bring an unfair dismissal. So the other way to say that is an employee cannot sue you for being unfairly dismissed if they've worked in your business for less than 12 months and you employ 15 or less employees. So that's rule number 1. So the reason for that is right now under the Fair Work Act, which came in 2009, they rejigged all the employment laws, and they basically wanted small businesses to have an opportunity to be able to give people a try. They want to see whether they're going to be the right fit. And they give the employer that has 15 or less employees the opportunity to consider whether these people will be the right fit for up to 12 months. And if they're not the right fit, or if they haven't performed very well, then that employer can terminate that employee within the first 12 months without any repercussions at all from an unfair dismissal. Which means if you were to terminate someone in the first 12 months, you can simply say, we've made a decision that you're not the right fit for our organization. There's probably no point of going into why you're terminating them. There's probably no point in putting them on a performance improvement plan. There's probably no point on doing any of that, because all that does is attacks the employee and essentially tells them that they're no good. Where if you just simply say that they're not the right fit, then that normally just doesn't open you up to any other liability, and it's just under the Fair Work Act, which you're permitted to do. Now, there are some exemptions to this or exceptions to this, and there's something called a general protection. Now, a general protection is under section 340 and 341 of the Fair Work Act. And it says where an employee exercises a workplace right, and as a result of the exercise of that right, an adverse action has been taken, then they can bring what's called a general protection claim. So as an example, An employee feels that they've been bullied and makes a complaint to their manager saying, Joe Bloggs is bullying me. And as a result, the employer doesn't want to deal with this because it's a small employer. They don't have many employees in the business. And if the people aren't getting along, the best way to do it is just eliminate one of them. So the employee then goes, or the employer goes and terminates the person that made the complaint against Joe Bloggs. In that case, the person that made the complaint has exercised the workplace right not to be bullied. And in response, the employer has taken adverse action by terminating them. In those circumstances, there's no minimum employment requirement. That could happen in the first week of employment. And if that happens, it still goes to the Fair Work Commission, but they deal with it as a general protection claim. And then if it's not resolved, it goes to the federal court. Now, an unfair dismissal, it's limited to 26 weeks damages of pay, whereas a general protection is unlimited damages. So if you are going to terminate someone within the first 12 months and you're a small employer, and you're just going to terminate them because they're not the right fit, make sure they have not exercised a workplace right when you're about to terminate them. And if you have, you probably need to talk to a lawyer because you could open yourself up to a general protection claim. The other area is unlawful dismissal and unlawful termination. And again, that applies to situations where someone has a legal right, and as a result of exercising that right, they've been terminated, or they've terminated because of something that's unlawful. So, for instance, Joe Bloggs is got a little bit elderly, he's not very good on the computer, you've decided to terminate him because of his age. That would be discrimination. Or another example is someone has taken annual leave because they're sick, and you believe that they're just sick because they took the Friday off and they didn't come in the Monday because they're hungover. Now, if they've given you a medical certificate on the Monday issued by a doctor, and you've terminated them because you believe that they're lying to you, you're most likely going to wind up having a general protection claim or an unlawful dismissal claim brought against you because they've exercised their workplace right to have annual leave or sick leave. They've issued a medical certificate to you, and as a result of doing that, you've terminated them. So if anyone gives you a medical certificate or a workers' compensation claim and or made a complaint before dismissing them within those first 12 months, you're probably going to need to talk to a lawyer to deal with it. Now, an unfair dismissal, going back to this high income threshold, if someone has worked, let's say, for 5 years, there's no time limitation at all on an unfair dismissal where somebody has makes more than $162,000 a year. So they're not protected from an unfair dismissal. So if you have an employee that's worked for you for 5 years and they make more than $162,000 and then you decide to terminate them, they can't bring an unfair dismissal claim against you. But what they can do is they can still bring a general protection against you, or they can bring an unlawful discrimination case against you. Or also there's another thing called executive rights law or wrongful dismissals, which is under case law, which goes to court. And there could be an argument that you breached implied duties of fidelity or good faith potentially. But there was once a time where I brought many federal court claims back in the early 2000s. I sued many employers for the breach of the implied duty of good faith and trust and confidence. And in Australia, we all thought that law existed, and all lawyers thought that law existed in Australia based on some English case law. And so I ran a lot of cases in the federal court and successfully settled almost all of them for the implied duty of good faith and trust and confidence. And then the High Court came along and said the duty of trust and confidence doesn't exist in employment contracts, and that whole side of my business kind of closed down. Just a quick summary in terms of employment law: you got unfair dismissals. You're given those 12 months if it's a small employer. It doesn't apply to someone in the high income threshold. You need to know about these general protections because they can arise and they're quite serious. You need to know about the unlawful termination if you terminate someone because of something that's unlawful. And then if they do make the more than $162,000, there are still executive rights that they might be entitled to under common law, which is in the courts. So that's my high-level employment summary of different areas of law that you can Google and have a look at, or ask me any questions now and talk about that. Now, let's look at your employment contracts generally and your policies. So my slides are frozen for a second. Let me see what's going on here. All right, so we want to look at legal compliance. So one of the things that really became quite popular during COVID days was whether you can terminate someone because they haven't been vaccinated. And when you looked at the terminating someone because they haven't vaccinated, the first case law that came along was in relation to some nurses and some workers in an aged care facility about flu vaccinations. And there were two Fair Work cases that came down that said that both of those employees, one in aged care and one in the hospital, were both terminated fairly by the employer. And what they looked into is they said, well, did they have due process when they implemented their policy? And was it fair and reasonable, or did it go beyond what the employer needed to protect? So for instance, you might have a policy that everybody must be vaccinated. Now, if you look at that nowadays, post-COVID, the question is as well, when did you implement the policy? How long have you given the employees to go and get vaccinated? And is it implemented fairly and reasonably? Now, fairly is looking at someone and saying, well, does someone get an exemption? Maybe they have a precondition and maybe that vaccine isn't appropriate for them, but is it reasonable? Do you really need to have it nowadays? And so all your policies, whenever you're implementing them, need to be implemented, notified the employee, probably the employee trained on it, and have to be fair and reasonable and does not go beyond your expectations or your reasonable expectations to protect your business. So one of the things is, if you're going to custom make something, you're probably going to want to consult a lawyer if you really want to rely on that clause, or if you really want to rely on that policy. And you don't want to go beyond your policy, because what will happen is that if your policy is really stringent, and then you decide to terminate someone because they breached that policy, it could all then go and unravel, because what will happen is they'll bring an unfair dismissal case, and then the court will find, or the tribunal will find, that all your policies are unlawful because they haven't been properly implemented, they're not fair or not reasonable, and then you'll have to go and redo everything. So that's one of the things to look at. So the first one is, there's certain national employment standards, and those things can't really be affected in when you draft your policy. So you've got the maximum hours that someone's allowed to work. So if they're under an award, it's 38 hours per week. And then there's allowances, penalty rates, and all that. So if your awards, let's say you have someone that's under the hospitality award, and you say you have to work 38 hours a week plus additional reasonable hours without pay to meet your duties. If they're actually on an award and you have to pay them the hourly rates, then that clause is going to be unenforceable, because any reasonable hours to perform afterwards has to be paid under the modern award that applies to your industry. But if you have someone that's award 3, so someone that gets paid well beyond the minimum employment standards, or well beyond the wage rates, then that kind of clause is reasonable and expected for someone that's in a senior role. Then you got to look at the flexible work arrangements. So if you say, for instance, we don't consider any change, or you have to work in the office 5 days a week without exception, then that's going to be unlawful, because you have to consider flexible work arrangements. If someone's being employed, so there was a case many years ago now, probably 2019, called the Lawpath case. And in that case, what happened was that there was an employee that had been employed for some period of time. They were casual, I'll just make it up, I think around 6 years. And then they were terminated from their employment. And they were terminated because they just weren't rostered anymore. They were casual. That person then brought an unfair dismissal case. Now, an unfair dismissal case can't be brought by casuals because casuals don't have a reasonable expectation of future work. And the reason they don't have a reasonable expectation of future work is because they work casual and they're rostered every 2 weeks and so on. However, if you worked a regular and systematic period of time or regular and systematic pattern of work, and you have an expectation of continuing employment, then it could be found that a casual is actually deemed a part-time employee. And in those circumstances, they are entitled to bring an unfair dismissal. And in this case, that's what that employee did. They brought an unfair dismissal case to the Fair Work Commission. It then went to a final hearing. And in that case, it found that the employee actually, even though they employed for, say, 6 years, the tribunal found that they actually had converted into a part-time employee back in around maybe 4 years or 2-year consistent period of time, and then ordered the employer to also have to pay all the back pay for the public holiday pay, the annual leave entitlements that they didn't get, the long service leave accruals, and that's about it. And so what happened then is that then the employer said, well, that's not fair. I've been paying them leave loading. I've been paying them 25% salary or 25% hourly rate above and beyond everybody else because they weren't getting those entitlements. And therefore, in this situation, we're happy to pay all the back entitlements, but we want that offset against the extra 25% wages that I've been paying to this employee. And in this situation, the court said, no, you get punished effectively. You can't offset wages against anything. And you can't offset your statutory entitlements against anything. So the fact that you've now paid that employee the extra 25%, that's your problem because you haven't complied with the law and you failed to pay all the entitlements as well. So the employee was able to double dip in this case. It then has gone on to appeal and then after appeal. But essentially I've used this as an example is that all employees who work on a regular and systematic basis have a right to convert into a permanency. So if you have a casual employee that's been working for 12 months and they're in a regular pattern of work, not only do they have a right to request to convert to part-time, you as an employer should also consider asking whether they want to convert in writing and see whether they want it. Because not everybody wants it, because some people want to be able to take unlimited leave, as much leave as they want. But you should make sure you request that in writing, whether they want to convert, because if you don't, it could be found out later that they actually are deemed a part-time employee, and you'll have to back pay annual leave entitlements, long service leave entitlements, public holiday pay, and so on. So again, have a look at that. Now, have a look at your policies in relation to this domestic violence leave. You're probably going to want to be including that now if you have it in your leave policies. And these are just basically a list of the national employment standards. Now, when you do implement a policy, a lot of times you'll take a template. So Lawpath has about 16 different employment templates. And if you don't have any kind of policies in your business, right now is a good time to have a look at it. You can go into the Lawpath platform and you can type in, if you're a subscriber, and you can type in employer handbook. That handbook then goes and identifies all the different workplace policies that exist in the Lawpath platform. And you can tick then which ones you want, and there's around 16 of them, and then you press complete, and it merges them all into one big handbook. And so even though you're using Lawpath's template to create this handbook, you still want to read it, you still want to go over it, you still want to make sure that every clause applies to your business and still tailor it for yourself. Some things might not apply, you might want to delete. Some things may seem unreasonable, not the kind of culture that you want in your business and things like that. So have a look at the policies. You want to keep them simple. You want to make sure that those policies are easy to manage, easy to follow, easy to train, easy to implement. Now, when we look at your employment contracts, if you have a clause in your employment contract that says that you're not entitled to any other leave, and you list off all the different leave under legislation and you don't include the family and domestic violence leave. Or if your employment contract says that they have 5 days for domestic or family and domestic violence leave, you don't necessarily need to change your employment contract. It just means that one clause is effectively automatically amended to what the applicable law is. So I wouldn't worry about getting all your employees to re-sign a new clause or new contract just because now they've implemented a change from 5 days to 10 days. So I wouldn't worry about that. But what I would worry about is if you don't have an employment contract at all, or if your employment contract is a one-pager. And so some of the things you want to be looking at your employment contract, and if you are bringing in new employment contracts into your workplace, is making sure of a few things. So you want to obviously put your employees' name and details, but you want to, and then you want to work out where they're going to work. A lot of times someone will hire someone from work from home. They'll say, okay, you can work from home. I never do that. I actually would say you have to work from the employer's location. However, for the first 6 months, you can work from home, which will be revisited, or you have to work from the employer's workplace. However, you have the ability and the flexibility to work from home in accordance with the company policy. Because a company policy you can change. An employment contract you can't without the employee's consent. So I wouldn't just say work from home in your employment contract. It would be work from your location, but then have a company policy, which is a work from home policy that has different things in it, such as people can apply to work from home. We allow people to work from home 2 days a week, whatever it is. But you got to remember that someone might sign an employment contract that's going to be binding on you maybe for 10 years. And circumstances might change, the role might change, the duties might change, your office location might change, and the nature of your business might change, like you sell it to somebody else. So have a look at what you've put for that, have a look at what you put when you're moving forward with new contracts. Specify the roles and responsibilities, and don't forget to include general administrative work, general managing of this. So you keep it specific, but then you also have that broad nature so that you are able to delegate tasks that aren't part of that role. And it's still going to fall within that roles and responsibilities that are specified in the duties. Superannuation contributions, they're going up and up and up. You can have a look at what the current rate is. It's 10.5. So old contracts might say 9.5. It's now 10.5 and it's still going up. You should have a confidentiality clause. You should have an intellectual property clause, especially if you're in software or in any kind of business where you're a service provider. You want to make sure that intellectual property contract is where that clause is really strict. The basis says that anything that's brought into existence, created, invented while they're employed by your business is owned by you. So that if someone working in your business might be a very strict niche area, and they might have all the detail of your business, and then they might come up with a brilliant new idea how to improve your business, and then they quit, steal your clients, and start up a new concept. You would be able to claim ownership of that invention potentially. And that also leads to have a non-solicitation clause, which is restraint of trade clauses. I'll just touch upon them. They're not always enforceable, but they definitely are. And people say, oh, these clauses aren't enforceable. That's totally wrong. Restraint of trade clauses and non-solicitation clauses are enforceable, and they're enforced almost every day in the courts in Australia. So if you're having one, or if your employee thinks that they're not enforceable, if you're an employee think they're not enforceable, that is totally incorrect. Now, a restraint of trade clause, generally speaking, has 3 elements. That is, and if your restraint clause doesn't have these 3 elements, then you should consider redrafting your employment contract immediately if you want to rely on these clauses. So it has to have a duration of time. Normally we have what's called a cascading clause, which says that the duration of time is maybe 24 months, 20 or 18 months, 12 months, 9 months, 6 months. And what that means, if you ever see it in the contract, it means that if at any time the court found that 24 months was too long and too broad and unenforceable because it didn't protect a legitimate interest in the employer's business, then that's going to be reduced by the court to 18 months rather than being struck off completely. And then you argue in 18 months, if that's too broad, then it's reduced down to 12. And so that's how you make a clause really, really enforceable by having that cascading clause. It also has what the restraint is. They're restrained from operating the business that's competitive to your business worldwide. That's probably not going to be enforceable because it doesn't protect the legitimate interests of your business, because you're probably not operating your business in Istanbul and you don't need a protection from that person operating in Turkey. But you might have, and then we do also have cascading for that. All of Australia, New Zealand, all of Australia, just New South Wales, 200 kilometers from the CBD of Sydney, for instance, and so on. And that's for the same reason, to make it eligible to be read down by the court. Some states grant the judges the right to read them down no matter what. Some clauses allow them to read them down under law. Other states don't have that law. So if you just have your restraint from 12 months worldwide, and a court finds that that's too broad in certain states, they'll just cross it out and say it doesn't apply at all. Now, the other thing is a non-solicitation clause, and I don't know why anyone just doesn't have this. It is imperative for almost all businesses to have non-solicitation clause, and that is that your employee is not going to solicit away other employees of your business to go start up a competitive business, or they're not going to solicit away your clients and go start up competitive business and deal with those clients. And basically, the court will enforce those clauses only to an extent that it's there, that's necessary to protect your legitimate interests. So again, it has to be for a period of time. It can't just say, you're never going to talk to our clients ever again. And it can't just say, you're not going to talk to our clients. It has to be that you're not going to talk to our clients or abate, or you're not going to aid, abet, elicit, solicit, or perform any services that are of competitive nature to your business to any of our clients who you've dealt with in the last 12 months for the next 24 months. So it has to be specific along those lines. And that's to prevent you running your business and then having your entire business stolen effectively by one of your employees by taking all your staff and all your clients across. And it happens, and it happens a lot. So I highly recommend considering that. Even those in the NDIS business, NDIS is all about freedom of choice in who you choose a provider. You can still have a non-solicitation clause stopping one of your employees from stealing your clients away from you. And then making sure you get your employment contract signed. If you don't ever get it signed, there's always an argument that it hasn't been accepted. So if you're negotiating it back and forth with track changes, every time you send it with track changes and every time the employee sends it back, it's an offer and a counter offer and an offer, a counter offer. And if you don't get an acceptance of your identical offer, then in those circumstances, it's going to be deemed that it was never actually binding because it was never being accepted, and therefore it's not enforceable. So that's effectively it. The last one is just look at your different policies. Again, make sure they're fair, they're reasonable, they don't go beyond the reasonable expectation and what your protections require in your business, and that they're implemented, everybody knows about them, people have been trained on them, or they've been given them, they've been told to read them. And there's a lot of new learning platforms out there, LMS platforms, where you can get people to do multiple choice questions on your policies if you're a little bit of a larger business and have an HR platform. But for smaller businesses, it's more about saying, here are the policies, explain it to them, get them to sign off saying that they've actually read them and understood them. Confidentiality agreements, if you don't have employment contracts in place, the minimum thing that you should be doing is getting confidentiality, non-compete agreements signed. But really, those clauses should just be in your employment contract. Touching upon, these are all the social media policies and so on. Again, it's you can have a read of these policies. You can probably understand what they mean just by looking at the title of them. But there is an interesting case called Byrne versus Dean. And I'll just touch upon that because it's kind of fascinating. Because in 1937, there was a golf course in England. And in that case, there was a golfer that every time he showed up, someone would put on the corkboard a notice saying, don't go golfing with him. And they would disparage him. And so every time you come in, you take it down, you tell the golf course not to post it. make sure no one else posts it. You come back and they say, don't go golfing with him. And effectively, he ended up suing the golf course for defamation on grounds that even though the golf course didn't make that publication, they allowed it to be published by not taking it down. They then have now applied that case to social media generally today. And so if you have a Facebook page with your company and someone is allowed to post on it, and third parties are allowed to post on it, and if it's defamatory and someone tells you it's defamatory and you don't take it down, you could be found liable as the publisher of that publication and be sued for defamation under the principles that are established in this case. So a lot of times with social media policies, we talk about monitoring your social media, but also there's cases where there was one case where a truck driver defamed his employer. I think it might have been Linfox, and said something in social media on his Facebook page, and they ended up terminating him. And it was found that he had breached the social media policy of the employer because as an employee, you owed a duty of fidelity and good faith to your employer, and you also can't say anything bad about your employer potentially in social media, and therefore you can do that by drafting a policy to protect your brand. And so you can have a look at the Lawpath social media policy. IT use is talking about, you know, standard things. Also, the fact that if you're using a computer issued by the employer, that you're allowed to moderate how that device is being used, and you can surveillance it as well, as long as you have that policy that allows you to do so, such as reviewing their emails, seeing what they're doing. And then touching upon training, I've talked about that, but more importantly, with occupational health and safety is the most important aspect. Under every state, you have occupational health and safety legislation. For instance, in New South Wales, you have the primary duty of care. An employer has a positive obligation to take practical measures to prevent health and safety. I had a case many years ago where someone died in my client's workplace. The main thing that he was being prosecuted for was not having a policy, not having procedures. We tried to say that there was verbal instructions, there was a verbal policy. It really didn't fly. The fact is the very first thing that you need to do to have an OH&S policy, and that's the first tick that you kind of need to protect yourself. So have an OH&S policy, make sure you have an anti-discrimination policy as well. And that's about it. So I will, just looking at the, thought that was just about it, but these are just the increased wages and the superannuation thresholds. And I've already talked about overlap time, already talked about annual leave, and I'll pass it back to Ryan.
Thank you, Damon, for the very comprehensive presentation. So I just wanted to go into how Lawpath can help. Damon has made a number of references here today on the Lawpath platform and how we can really assist out with your employment compliance. So getting your employment contracts in place, getting your employee handbooks in place. We've now updated the domestic violence policy with the new change in legislation. So if you have a policy, would be wise to revisit that one as well. But the three pillars of Lawpath is the contract management for your business. So getting 400 plus legal templates that you can customize and brand with your business's logo and ABN and make it look really professional. We also have built-in e-signature to the platform. So it's designed to be an end-to-end contract management system, which allows you to create, sign, and store these documents securely. Secondly, we do have the personalized workflows, which go through different things around setting up a family trust, employing someone new, employing a contractor, signing an NDA, collecting a debt, even registering a trademark. So they walk you step by step through the process of it, which can be very helpful and directly link you to the required documents. And then lastly, we have booking in legal consultations. We also have accounting consultations with our chartered accountants. So if you'd like to speak with Damon or a member of our team or on lawyers or accountants to review matters, then you can do that at any time. We also have a legal health check as well on our website, which does go through any legal gaps you might have in your business through a range of different areas. And then we combine this with our accelerator program to ensure that you're getting maximum value from our services, but so the lawyers and accountants can go holistically through the different aspects of your business to ensure that you're remaining compliant legally. So our plans, as you can see, we've got two main plans. We've got our legal advice plan, $120 a month. What this does provide is unlimited 30-minute calls each month with our lawyers. So you can speak to Damon, Sam. We've got multiple other lawyers on the plans who specialize in different legal areas. It does give you 4 pages of contract review. So especially if you have an employment contract, you want to review the award you might be under. There might be specifics around topics that have been mentioned today that you want to clarify whether you should amend them or get some high-level guidance. This is great from the legal advice plan, especially with these calls. Now, you do have the option to do a voice call or a video call with the lawyers. So again, that we've added that in, as well as lawyer chat. So if you're currently on this plan, you can type questions in and get a speedy response back from the lawyers on matters that don't require a consultation. Secondly, we have the legal and accounting advice plan. So if you do require high-level chartered accounting advice for things like group structuring and asset protection, you can combine the two. And the lawyers and the accountants, they do communicate with each other, so you're able to get the full package in one. It does include an ASIC and an ATO agent service. So if you do require company changes to be done on your behalf, such as changing shareholders, changing a registered company address or an office holder, that can be done by our company's team. So today's special offer for all webinar attendees is 25% off our legal advice plan. It does go for $120 a month standard, which again is very economical considering lawyers can charge anywhere from $400 an hour and up from that. But 25% off brings the rate down to only $90 a month. So if you would like to take up this offer and you do want to get some advice, some review of contracts, you want to get just assurance that what you're doing is correct, please type yes into the chat or the Q&A box below, and one of our team will reach out to you after the webinar. Just keeping in mind that any money spent on a subscription product with Lawpath is tax deductible at 120% due to some changes in the budget last year, and we're more than happy to send some pamphlets out to you as well. So if there's no further questions on the offer or the Lawpath platform, I'll put it back to Damon now to answer the bunch of Q&A that has come in during the presentation.
All right, great. Thanks, Ryan. So during this, if you want Lawpath to contact you to get those subscriptions and the discount, just press yes into the chat. But in the meantime, if you have any questions, throw them into the Q&A and I'll get through those. So I'm just having a look at the chat, make sure no one's posted anything in there. Also, just to let you know, we also have a YouTube channel as well. So if you're looking to raise capital, if you're looking on anything about shareholders agreements, founders' rights, preference shares, creating a trust, corporate structures, all that kind of stuff, I've done a ton of videos on YouTube, which also might be able to answer your questions. All right, so let's get into this. So is the family and domestic violence in addition to personal leave, i.e. for sickness? Absolutely, yes it is. So this is in addition to your standard 10 days per year sick leave, in addition to your standard annual leave entitlements of 20 days a year. Is a contractor the same as an employee from a vicarious liability perspective? If a person only occasionally does work for the company, for example, if they contract through a freelancer and might do between 0 and 5 months or 5 hours a month. Interestingly, I've just had a case and I've just been reading a bunch of case law on this area. So in terms of vicarious liability, it's normally someone that has acts as an agent on behalf of the employer. And so it can apply to a contractor. It definitely, so for an employee, it always applies unless the employee is grossly negligent. So an example of this was in Ireland, of course, many years ago. I think it was in 1972 or so. I read a case about a truck driver went up to the gas station and was smoking a cigarette and blew up the entire gas station. And in that case, it was found that the employer that owned the truck was not vicarious liable for the action of the employee because it was grossly negligent, that anybody should have known better not to smoke a cigarette while filling up their petrol tank. So that's just an example of that. Now, I'm doing a case right now dealing with this, and under the section 182 and 183 of the Corporations Act, it says that an officer, director, or employee of a company must not misuse information for the benefit of themselves or for the detriment of the company. And it says that they must not misuse information or documents, essentially. And then if you look into what is the definition of officer, officer is defined as anybody that has any kind of authority or control that could potentially affect the company's viability in essence, and that's defined in Section 9 of the Corporations Act, and it's fairly broad. And so there was a case where a consultant was hired, came in, started taking increasing roles and responsibilities as a contractor, ended up becoming a director of the business, ended up managing the entire business. And even though he was a contractor, and it didn't matter whether he was a director or not, even though he was a contractor, we found that he was an officer of the company. And as an officer of the company, he had a fiduciary duty to that company. And so this is worked by way of analogy of whether it doesn't matter whether an employee or employer is liable for a contractor or employee. It goes to whether the relationship, it will look, so an employee always, except for gross negligence, a contractor, you look at the current circumstances. I act for about 17 software companies, and when someone infringes my client's software by illegally downloading a cracked key to access that software, we normally send a demand letter to the person that infringed, and a lot of times it's a contractor who has infringed. And the law around that is that if the employer had an opportunity to take reasonable steps to protect the infringement, and then they're going to be generally liable. So long answer, but if someone works as a freelancer for 5 hours a month, just doing very simple freelancing work, unlikely you're going to be vicariously liable. But if they're doing that work and dealing with your client specifically, and they're actually engaging in performing services on behalf of your business rather than to your business, then you probably will be held vicariously liable for the actions of your contractor. Now, in relation to the casual doing work for 1 hour, how does this work if someone contracts through a freelancer, if they have their own company, and we can assume that they might provide short-term services to multiple companies? Now, if you're just hiring someone for 1 hour's work and they're a contractor, the award rate doesn't apply. So the award only applies to employees, not to contractors. That's number one. Number two is, if they're only doing 1 hour here or there, then as a contractor, then you're not going to have to worry about them becoming a deemed employee. Under the Australian Tax Office, there is a way for a contractor to be a deemed employee. So from a legal perspective, they're still a contractor. From a tax perspective, they're actually an employee. And if they are a deemed employee, then you have to pay them super, you have to withhold their tax. And so if someone primarily provides services to your business, and a majority of the services that they provide year on year is to your business, then it's likely for them to be deemed an employee. So if they're doing 1 hour a day, or if they're doing 1 hour here and there, you don't have any problems. They're a contractor and they're not a casual employee. If you're doing 5 hours a week or 10 hours a week consecutively from certain hours, then it's probably possible that they could become a deemed employee because they're doing 25 hours a week. The majority of their hours are probably with your company. So you got to be careful of that. But a contractor is not an employee from a legal perspective. But there's always a way for the courts to look into it and see, well, is that really an employment relationship? You just called it a contractor. What is the actual relationship? And there's many different factors to consider it. I'm sure Lawpath has an article on it about looking at whose tools are they using. Are they using their own computer and their own internet and their own mobile phone, or have you supplied all that to them? So I could go in for hours about this kind of law, because this is what effectively has shut down all the ride sharing businesses who have basically done a runner from Australia. There was one called I think ASAP, Fedora, think maybe even deliverer, where they were all ended up becoming deemed employees, and basically they had to shut down and run because of the liability that they were opening themselves up to. And there's case law after case law, and it gets very, very detailed. And I could talk for hours about it. So is there a fixed term, if the fixed term contract is in order to hold a position for a permanent employee who is assessing temporary flexible work arrangements, can the 2-year be exceeded, i.e. parental leave followed by the birth? Absolutely. Yeah, that would be very specific. So if you're putting someone on a fixed term contract because they're covering maternity leave, and then someone ends up deciding to take the next 12 months after that maternity leave, and you decide to renew it for another year, number one, it's going to go over that 2 years mark. So that would be concerning, but that's specific for a specific reason, which is the maternity leave. And it's not going to affect maternity leave laws around being able to put someone in a fixed term contract for that. So I wouldn't worry about that in any way. But if you were to then bring back the person that was on maternity leave, and you were decided that you wanted to keep them on and renew them for another 1-year contract, probably you would get caught up, because you would have to make a decision at that 2-year mark whether they are going to become permanent or not. Does employment law apply based upon the location of the employer or the location of the employee? If so, someone lives in New Zealand and they contract to a company in Australia but works mainly in New Zealand, are they employed in New Zealand or Australia? High level law is this: the Fair Work Act applies to Australian businesses or any business registered in Australia to provide services. If the employment contract is offered to someone based in Australia and then they go overseas, the Fair Work Act applies. For instance, you issue your employee contract and then they go off to the oil rigs, or they go off to Europe or something, the Fair Work Act would apply. Or if you issue a contract to somebody overseas for them to perform services in Australia, like they're going to relocate to Australia, then the Fair Work Act applies. But if you have a situation where your employee is not in Australia and is not going to be coming to Australia, that is unlikely the Fair Work Act will apply. And if you think about it from a high level, it kind of makes sense, because how do you withhold tax? They don't have a tax file number. They don't have a superannuation account. So you can't pay super, you can't pay tax because they're not here, and they're not registered here. So a lot of times, if you had a New Zealander who was performing services and they were living there, you normally hire them as a contractor. And the Fair Work Act wouldn't apply to them because they're not in Australia, they're not performing services in Australia, and they have no intention of becoming here. But then that also, sometimes we want to do the right thing by that the New Zealander, because if they're a contractor, they might have troubles getting mortgage, they might have troubles getting loans and so on. And they're not getting the equivalent to super, and they're not getting their annual leave entitlements, and they're not getting all these things that other employees would get. So a lot of times people find these labor hire businesses based in the host country, and they go and get them hired as an employee through this labor hire business. And that labor hire business then registers them as an employee with them and gives them all the employee entitlements that person would have got if they were hired by a New Zealand business. So if they are doing that, that's something you can look at, but no, Fair Work Act won't apply in that situation. Does the high income threshold include bonuses and superannuation, or is it only on the basic? It's only on the base generally, but again, the law is funny that way. There's case law on everything, and it normally doesn't include different allowances and commissions and things like that, but there is case law out there about reasonable expectation of commission. So if someone's been employed for 12 years and I've got the same commission over and over again every single month ongoing, there might be a claim for that is part of the income, but unlikely. But when you look at damages, if they were to sue you for an unfair dismissal, there is a possibility they might be able to claim that commission if there's a reasonable expectation to get it. But the law is very complex in this area. But high level, when you're looking at the high income threshold only, the legislation is base rate, and that's it. Anonymous attendee, is it 162 base, not salary, not, yeah, it doesn't include super bonus, so on. I have another meeting I have to attend to. This is being recorded. It is going to be up on our YouTube channel as well. Another question, and then I will leave it there because we've gone over. I have answered a lot of the one question. So does an employment contract need to be wet ink? No, all the states have changed laws. Corporations Act changed laws. Electronic signatures are now acceptable. And is the farming industry, is it lawful to interchange weekdays? You have to have a look at your award. There's an agricultural award that will deal with how you roster and how you change. And normally it's about an average over a month and how you change it, but that would be specific to the award. And I think that's about it. So I'll pass it back to Ryan. Thank you very much. I know I haven't got through all the questions, but we have gone over by about 10 minutes. So I'll leave it there.
Perfect. Thank you so much, Damon. And this is always a popular topic around employment. A bunch more people got some questions here. So again, really want to reiterate the value of the legal advice plan and the Lawpath platform. Not only do you have those documents, but you can get 25% off the legal advice plan today. A lot of great questions here from other people that we didn't quite get to because of time. So again, would strongly urge you to check out the legal advice plan. For as little as $90 a month, you could be talking to Damon sometime this week. So I would highly recommend it and suggest it. But thank you to everyone for attending the webinar. We will put a copy of the recording on our YouTube channel by the end of the week, so you can access it there and all of our past webinars. But just before everyone leaves, I will just post up a feedback poll so we can get some bit of data on how we can improve the webinars going into the rest of the year. But thank you everyone for your time today, and we will see you at our next webinar. Thank you.
Thanks. See ya.